The topic today maybe at first look doesn't really make a lot of sense because CPBs and contract registers are two discrete issues. So you could think that we just brought them together for no good reason. But I think that once we adopt the competition perspective, it makes a lot of sense to talk about both of them because both create issues that are common to the information we gather, how do we exploit it, and what is the effect in the market. So the idea today is just to provide you an overview of the new rules, both on central purchasing bodies or CPBs, and what the Commission is thinking about maybe doing in the area. And I need to stress again the caveat that even if I'm a member of the European Commission Stakeholder Expert Group for Public Procurement, my views not only don't represent the Commission, but usually are in stark conflict with the Commission's views. So don't take anything I say as the Commission's word. And in particular, about the paper you have in your materials, after having read the draft, the Commission got in touch and said, you need to stress that the strategy for centralized procurement is not adopted. So it's not an official document of the Commission. It's an official document of the services of the Commission, which I'm sure that being lawyers in the room, you will appreciate is an important nuisance. And then once I have spoken about this and the issues about contract registers, which are absolutely adopted and are definite policy option of the Commission, I will try to unearth the competition implication of both of them. Probably I'll do it sequentially just to structure my thoughts. First thing about centralization. Now, centralization seems to be the new thing, and all member states are thinking about centralization, how they can pool together their procurement activities, be it because they are under dire financial constraints, so centralization is seen as a tool to save on the administrative costs of procurement, and that's an important driver, or because they want to become really smart in the sense of exercising the buying power that they hold. So it's about putting together volume so we try to get better results. And this is the received wisdom, and I'll think about it in a bit. But it is so important that in these indicators on public procurement performance in the member states, which are part of the scoreboard on internal market that was mentioned this morning, one of the 6 indicators that led to that map on which countries were red, which countries were green, is about aggregation. And in particular, it's indicator number 3. And under indicator number 3, it is simply measured how often public buyers buy together and what proportion of procedures are covered that are useful for for more than one buyer in a member state. So basically what they look at is what is the percentage of total procurement that is centralized somehow. And for some reason, the threshold is at 10%. So if the member state centralizes more than 10%, then green light. If it centralizes less than 10%, red light. As far as I could dig, and I spent quite a lot of time, I couldn't find any justification for the 10%. I think it's an arbitrary cutoff point, and I think that the problem is that it's reverse engineered. So basically, if you look at what is the percentage that member states do centralize today, and this is information close to 2014, because as we know, procurement data, where it exists, it comes with a bit lag. And this is the information the Commission used for that scoreboard. What we see is that there are very high volumes of centralization in very small states of the EEA. So for some reason, Iceland or Malta, being very small member states, they centralize a lot, which seems to make sense because they probably don't have dispersed administrative network. But then we have fundamentally 50% of the member states under 10%, 50% of the member states above 10%. So, if you don't have anything else to go by, it seems like a cutoff point that comes quite naturally. Now, the problem that I have with this is that using an indicator that is purely volume-based, saying more or less than 10% is centralized, is telling me nothing. One of the winners in the European Union here, the one that should get the medal for, leading in this, is the UK, where more than 20% of the procurement is centralized. Looking closer at what the UK does, I would think that probably we should reverse it, and the more you centralize, the more we should distrust how solid and robust the delivery of your procurement is. Only this week, we have this scandal in the press about the Scottish schools. So basically, every Scottish school built after 2009 is structurally unsafe. And it is structurally unsafe because they were all built under one framework contract. Why? Because they were the first to implement frameworks for works, which is not what you think about immediately when you think about frameworks. And of course, they gave most of the call-offs under that framework in Scotland to the same company, which built exactly the same school, modular school, everywhere in Scotland. And you got the first one wrong, all of them are wrong. So is centralization understood in this way just a pure metric of what percentage you are centralizing without any qualitative assessment useful? It is not. The second point about the data is that this is about how much do you centralize when you tender. But this is not about how much do you actually centralize when you call off. So this is about how many frameworks are created, but we don't look at how many of them are executed. Another particularity in the UK, if you want to buy chairs for a school, you may be able to draw from 4 different frameworks, because you have a framework from different regional consortia of schools. So for instance, in the Midlands, where I used to be based, they have EPSO, and they have a framework for chairs for schools. But the Crown Commercial Service also has a framework for chairs for schools, and that can be replicated. So in the end, if you're a school in a specific catchment area, you can choose between 3 or 4 different frameworks, which means that the volume of centralization or aggregation has been counted 4 times for the purposes of these figures. So I'm also not certain that this reflects reality. So this just would be a very short cautionary tale, but I think it serves to say it's very dangerous to build purely metricized quantitative data and on basis of that develop policy results. And I think going back to the issue of 10% more or less, this is very important, because if you want a quick gain in the scorecard for next year, if you want to move from the red to the yellow or the yellow to the green, you just have to create one absolutely random framework agreement that nobody's ever going to use, so you don't even have to put your money where your mouth is, but you just create a massive one that's going to cover the whole public sector, and it's going to put you up. Again, example in hand, the UK. In the UK, the Crown Commercial Service tendered framework contracts for all marketing activities of the public sector and all public engagement activities of the public sector. These are multi-billion pounds framework agreements, and I'm curious to see if they ever release information about how many of them actually resulted in call-offs. Because I don't really see the City of Manchester using, for an organization of an event, a framework run from London. I just don't see that happening. So they won't. So I think this is the first thing. We are moving in the wrong direction when we're talking about data. The data we want is about what actually happened in the execution phase. And we want more nuanced qualitative assessment before we go completely full tilt into the use of this to indicate best practice. I think best practice is very difficult because it's really qualitative, and you cannot quantify it. Could stop speaking now, and we could have half an hour discussion, but I have a few more things to say. So my problem with the strategy for centralization and collaboration is not only about how we measure it, but it's about what seems to be the push the Commission wants to develop. Now, what is clearly adopted is the public procurement strategy. This is available in the website of DG GROW. It has several points of strategic development for the future years, and one of them is that they want to facilitate aggregation of demand. And they say that they pursue this policy point with the intention of supporting dissemination of good practice and to promote the use of innovative procurement by CPBs and other forms of aggregation of demand. Now, here, the problem that we can have is that we are conflating 2 areas of innovation and good practice. Here, we're not talking about acquisition of innovative products or services. We're talking about innovation in the process of procuring. So basically, this is a strategy aimed at streamlining administrative procedures and supply chain management procedures in the member states. And I start to feel that maybe the Commission doesn't have legal competence to do this, because there is a very thin line, but there is a line with the right of self-organization of the member states at administrative level. And I think that pushing for centralization of the activity of buying has implications for how they decide to organize themselves. Linking it to Advocate General Mengozzi's opinion in Regio Post for a completely different point. This does have an implication on the split of competencies internally within the member states, be it based regionally, be it based on activity. So I think that this is a bit problematic. But on top of this innovation of procedure, and this is where the work in progress starts, and I don't really know what is the state of the game now. The last information I have is from meeting earlier in the year, is that the Commission is really willing to maximize the use of Articles 37 to 39 of Directive 2014-24. So basically, what the Commission wants is to start having test cases on centralized, but most importantly, collaborative procurement, and if possible, cross-border collaborative procurement. Now, just a small overview of the possibilities that these articles put on the table subject to decisions on transposition. Article 37 basically is an extension of what used to be Article 11 in the 2004 directive, and it simply says that member states can authorize or allow for central purchasing bodies. The innovation is that now we can have two different types of central purchasing bodies. We can have what I would call wholesaler central purchasing bodies, which are those that buy to then resell, and they're developing an economic activity. And then we can just have agent central purchasing bodies. They are the ones that create frameworks, dynamic purchasing systems, electronic catalogs for contracting authorities to draw from them. If you only read Article 37, you think that the options are completely open and neutral. So 37 doesn't make any value judgment on whether one organization of a CPB is better than the other. But something must have happened during the trialogue that led to this. And as far as I could see the public record, I couldn't find it. But in Article 39, member states can prevent their contracting authorities from resorting to either one or the other type of central purchasing body from another member state. So when we integrate the cross-border element, when a contracting authority in the south of Spain considers whether to buy chairs for the school from the centralized purchasing body in Madrid or in Lisbon, then the option is not neutral, because Spain could decide that you only buy from the Portuguese one if it's either a wholesaler or an agent, or it could decide not to say anything. My best guess is that this is fundamentally a request from Scandinavian countries that have quite a lot of distrust for public intervention in the economy, and they probably don't want their CPBs to become wholesalers. So it's fine, you set up frameworks, and then the contracting authorities buy from the supplier through your framework, but we don't want you to buy a very large amount of chairs and then having to sell them. And this is something that happens in the UK, once more. And you see entities that are regional central purchasing bodies that buy bulk, and they place firm purchase orders. So they buy 1,000 chairs, hoping that the schools are going to need 1,000 chairs. They don't need them, and what they end up doing them is selling them in the private market at a discount. As a competition and state aid lawyer, I could not be more scared, because what I can see is that you're going to run your numbers. You're running a CPB, say in Italy, Consip. You know that historically you're selling about 50,000 computers a year to the public sector. You're going to buy 55,000, you get an extra nice discount, and if by the end of the fiscal year you haven't sold them to the public sector, then you go and sell them in the private market. So I think that what is implicit in all of this is that the nature of CPBs is changing. The directive is allowing for a multiplication of different models of business enterprise in the CPBs, and it's also natural that once you create the CPB, you don't know what's going to happen with it. So the CEO of the CPB probably is going to have a very massive financial or not incentive in maximizing the volume of the acquisitions that the CPB runs. So we're going to see lots of mixed activity that is going to be difficult to distinguish between what is pure public procurement instrumental to public mission and what is economic activity plainly called in the market. If we're talking about chairs in schools, maybe the implications are not too worrying. When we're talking about software, we're talking about new technology, we're talking about potential competitive dialogues or innovation partnerships with CPBs, then things get a bit more complicated. The second thing that Article 38 allows for is joint procurement, which basically is allowing for public-public cooperation between contracting entities for the carrying out of the procurement process. So it's not public-public cooperation for the delivery of the good or service or work. It's in the process of buying. And Article 38 is pretty much what any parent would have imposed. If you have two siblings carrying out an activity together all the time, they're both basically jointly responsible for the outcome. If they only do some things together but the rest separate, then they're only jointly liable for what they do together. Again, it's a purely enabling provision, but it doesn't really tell us how to sort out problems in practice. So after having given it some thought, I came up with this. And this is my conceptual framework to try to assess whether Articles 37 to 39, in particular 37 and 39, so I'm going to put out 38 for now, can work in practice. And I'm going to try to crack this horrible drawing in 4 bits. So if we think about it, the most extreme system would be where 2 central purchasing bodies in different member states want to cooperate for the acquisition of a specific good or service, and that good or service is going to be supplied by providers from any member state, so it could be from the first, from the second, or from a third member state. And contracting authorities in both member states are going to be able to draw from that macro framework agreement. If you think I'm dreaming, this is in place in the health sector. The HAPI project in the south of France has this in place for the acquisition of CT scanners and other very complicated hospital equipment for both France and Italy, and they're also willing to serve any other contracting authority in Europe. I also know of other projects that they didn't manage to get real because somebody with a bit of brain and probably risk-averse in the legal department killed them before they went public. But the issue here is, let's try to understand what is regulated and what is not regulated in the directive. The first level of relationship, which is the relationship between CPB in one member state and CPB in the other member state, may or may not be regulated. And if you read Article 39, you would think that it requires an international treaty for these 2 CPBs to coordinate each other, fundamentally because we have one public administration cooperating with an international public administration, and frankly, international public law says none of these 2 people have legal personality in the international sphere, so you would expect an international treaty is necessary. But the directive is not too worried that when it says, well, in the absence of an international treaty, they need to agree on specific things. So they need to agree on some points of choice of law. So my first problem is that you can have very formalistic member states when they're going to enter into a bilateral treaty to organize this cooperation, whereas others are going to be completely informal about this. I would not be surprised if the UK and Ireland just sign a memorandum of understanding on the back of a napkin after a dinner, and that's going to be it. So I have a first issue with international public law implications of this, but that's not for today. Imagine that they decide that CPP1, because it's bigger, because it's better, is going to be the one running the framework for both countries. Fair enough. They also decide that out of goodwill, CPP1 is not going to charge CPP2. So there are no major implications at the level. Now we have 3 other legal relationships we need to look at. There's going to be what I call relationship 2, which is the relationship between the suppliers to be included in the framework agreement and the CPB. And this is something that the directive addresses. And it says that the law of the member state of the CPB is going to control this relationship. And there is nothing new here. So if a CPB creates a framework agreement, it's going to subject it to its domestic law. And it's going to be subjected to that domestic law for the procurement aspects, but also for general administrative law aspects, contract law aspects, consumer protection aspects, data protection aspects, tax law aspects, whatever you want is going to be there. Now, the problem that we have is that this framework is going to be for the use of contracting authorities in 2 different member states. And the first question then to decide is, first, what is the law that is going to apply to the deliveries under the framework of one jurisdiction to a contracting authority in a different jurisdiction? So to go back to my example about the chairs in Spain, so if Spain and Portugal in the future have 2 CPBs, they set up this agreement so that only, say, the Portuguese contracting authority buys chairs for schools, and the entity in the south of Spain wants to buy those chairs. The framework is subjected to Portuguese law, but will the delivery of the chairs also be subjected to Portuguese law, or will it be subjected to Spanish law? And this is not neutral, because as a Spanish lawyer, unless they rescind my law degree, I can tell you, it is illegal for a public authority to subject itself to public law of a different jurisdiction. So it can choose to subject itself to private law of a different jurisdiction, but not to the public law, because it has a constitutional requirement to act under Spanish law. Which means that we cannot have a unique solution, and either we split the public and private law aspects of the relationship, which is going to be very difficult to do, or it's not really going to work. What my colleague Gabriela Raca in Turin, which is the ideologist behind the HAPI project, tells me is that they managed to accept, so they managed to get the suppliers to accept that depending on who draws from the framework, different law applies. And I challenge anybody with experience in investment arbitration to tell me that this is not going to be considered a material negative amendment of contract conditions, which probably going to give you rise to an indemnification, because it's an open clause, and the discretion will always be against the supplier. So there are going to be massive implications of this, not when you're selling shares, but when you're selling other things. The second is the issue of relationship 4. And relationship 4 is the relationship between the contracting authority and the central purchasing body. Here, again, this is something that the directive sorts out, and it says that in that relationship, the law of the member state where the CPB is based applies. I have the same problems. I'm not sure that a contracting authority in Spain can act under French law or Finnish law or choose your EU law when it's drawing from that framework. And I'm not sure from both legal and practical perspective. Legally, I already said what problems I have. But practically, so really, are we going to have in every municipality an expert in 28 legal systems? Because that's the other thing. I mean, the knowledge in language and in legal terms to be able to benefit from this is just absolutely crazy. But the one that I really love, and it's the one that is going to end up in the press, is the relationship, economic relationship between the suppliers and the CPBs. Because the way that most central purchasing bodies are financed is not by making the user contracting authority pay, but it's through a kickback from the suppliers. So for instance, in the UK, every supplier included in a framework tendered by the Crown Commercial Service, every time it receives a call-off, needs to pay 2% of the call-off to the Crown Commercial Service. And that's how we finance Crown Commercial Service. Which means, going back to my example, that 2% of the budget of a small municipality for school chairs go to pay services to the Portuguese central purchasing body through the supplier. And I have all sorts of issues here. I have issues of legitimacy, I have issues of taxation, I have issues of budgetary constraints, because it's an indirect way of making a payment, and maybe it needs to be accounted for differently. So I'm not saying it cannot be done. I'm just saying it requires a lot of legal engineering that the directive definitely does not sort out. Now, if I scared you enough, let's go back to the issue of, are central purchasing bodies going to be beneficial? And I think that once you start taking all these things into consideration, whether such a push for centralized purchasing bodies is going to give you positive net effects is very unclear. It's very unclear from the pure economic perspective, because maybe you can buy 5% cheaper from the CPB in the other member state, but the administrative cost of doing it is going to be much higher, so how do we trade off each of these things? But the second point, and that's something I had to say for now, it's about litigation. Because you will have to be ready to litigate as a public authority in a foreign court under foreign law if something goes belly up. And the cost of that litigation, depending on which jurisdiction it is going to be really, really high. Going back to the example of the UK, imagine that the Crown Commercial Services, because it has lots of buying power, offers you very good price on something that is a service. So basically, you don't care that the contract lies in the UK, you just want the software license and you're going to use it in Spain. And then all of a sudden, you need to go and sue in the UK before UK courts, paying UK fees and UK barristers as a public authority to be able to avail yourself of rights. Well, basically, you save the cent and you spend the dollar, because it's going to be much more expensive than any savings you could have, and that's assuming you can legally do it. The second thing about the way it's financed is that, again, you can be triggering all sorts of issues on how to tax these payments. because the contracting authority will have paid some VAT on this, then the kickback goes to different jurisdiction, and who keeps the VAT of these things? And I'm no tax expert, so I'm not going to venture any opinion, but this is going to be a feast for tax planners. Now, the other thing is about better service, and the best thing I heard about the Crown Commercial Services frameworks from a practical perspective is that it's just a framework manufacturing entity. Basically, what they do is that they set them up, looks really nice, they can report to the national parliament and everybody that they have set up all these frameworks, but then they don't provide you any support once you try to use the framework. So the end user basically has this problem that nobody in Crown Commercial Services is reacting to their needs. They cannot really contact directly the supplier because they maybe don't even know who it is. So as a user, as a tiny entity that doesn't have lots of capacity, I'm not sure that you're in a better position to get yourself heard by the central purchasing body than you would be by a supplier. So from the point of view of what serves your needs best, I'm not sure where we are. And the final thing is whether this is a Frankenstein waiting to wake up. And my comment goes to competition law. And the issue is, okay, we have been relying for the longest time on the Fanin case that basically said procurement in itself doesn't need to be separated from the downstream activity, so we don't assess procurement as an economic activity for the purposes of applying competition law. So you create a CPB, the only thing it does is buying. Buying is not an economic activity in itself, so no competition law enforcement. I don't really see this holding water once you have massive CPBs exercising very significant buying power, and I think that the Court of Justice has started tilting in a different direction. So in the recent Easy Pay case, the Court of Justice, and it's a bit of a different case because it was a case on whether the monopoly for pay orders to pay social security benefits was exempted from compliance from competition law because it was part of the social security system in Bulgaria, or whether the payment was separated from the granting of the social benefit, and therefore the activity of paying had to be subjected to competition law. And at least in the wording, the Court of Justice didn't say, oh, paying is not an activity in itself, so I'm just going to consider this is social security. So there's no need to differentiate, which would be the equivalent under Fanin. What the Court of Justice said is that there was a burden for Bulgaria to demonstrate that both activities are inseparably connected. And I love it. I mean, I wrote this in 2011 in my book. And if it ever happens, I'm going to be very happy. But then you better shut down the CPBs. Because once you have competition law implications for CPB activity, everything we have said here, that relationship 1 is not regulated, that's not true. That's subjected to Article 101 on the Treaty on the Prohibition of Cooperation between Competitors. And of course, then we're going to have Article 102 on abuse of dominant position. And then we're going to apply to the CPB the same rules that we apply Intel, or that we apply Microsoft, or we apply any others that have very significant buying power. And that basically means we're going to straitjacket them because, of course, all these savings we expect to get from exercising buying power will most likely be anti-competitive. So, again, another feast waiting to be served to the lawyers. And, of course, you could say, well, wait a minute, because this is still public sector, so what about giving it an exemption as a service of general economic interest, saying, look, getting savings for the public sector when it buys is a proper public interest, so we're going to declare it a service of general economic interest. And here, my problem is that the Court of Justice has gone everywhere in this case law. Again, going back to Altmark, you would think that the 4 standard Altmark conditions apply, so you have to define the SGI, you need to predefine the system of compensation in a way that is clearly transparent, you have to make sure there's no excessive compensation, and under the 4th condition, if the provider is not chosen under a public procurement procedure, then you need to benchmark it against a notionally equally efficient provider. And that's Altmark. And under Altmark, you would say, well, if the CPB is entrusted, so you have the use of the CPB mandatory by a law, and you define that that is a service of general economic interest, and then you make sure that the CPB doesn't get excessive compensation, then you can save it. But the problem I have there is that we don't really have a notional alternative. So we can benchmark one CPB against another in different member states, but that's not going to be very meaningful. And more importantly, we still have to assess whether reserving the activity is in itself state aid, because it gives an advantage that nobody else gets. And if the reservation of the activity is state aid, then that means that you would have had to notify the creation of the CPB to the European Commission. If the CPB exists today, you haven't, because no member state notified under the state aid rules the creation of the CPB, which means that formally speaking, this is unlawful aid because you did not respect the waiting time of Article 108.3, so you would basically have to wind it up, notify, recreate it, or get to an agreement with the European Commission on how big is going to be your fine under Article 258. So, and I don't really see DG Comp sitting on the same table with DG Grow and agreeing on a policy because it would be the first time it happened. So until now, there's been no coordination between the different Director Generals, so I can really see them pleading for different arguments, but I don't really see how this is going to happen. Now, the problem is that the Court of Justice allegedly is turning social. So Altmark seemed to be the standard for the longest time, but then we had Spezzino. Spezzino, a year and a half ago, contract for the direct award of ambulance services in Italy. And if you were to apply Altmark, there was no way you could justify the award. Why? Because they relied purely on an article of the Italian Constitution that says that third sector entities are an important part of the state and therefore the state can choose to cooperate with them. And that was the legal basis they used, but there was no clear act of entrustment, there was no clear definition of an SGI. And then they were not chosen through a public procurement procedure because they were direct awards to the Red Cross and other institutions. And you could not claim that they were efficient compared to a notional provider because they simply were not. Also because the rules are very different, so they paid some overheads and the cost of providing of the service, but they have volunteers, so it was not very clear how to measure what would be the labor cost if somebody else were to provide the service. And the Court of Justice deviated from Altmark with no explanation and created a new test. And the new test is not if you are equally efficient as a notional competitor. The new test is if you contribute to the public interest and to budgetary efficiency. Now, I have spoken to several economists and I asked them, what on earth is budgetary efficiency? And they told me, well, that means that the budget is balanced. So you could have a budget of 10 million or a budget of 100 million. If your input is equal to your output or if your income is equal to your expenditure, both of them are efficient budgets. So it doesn't tell you about the cost of the provision. It just says it's balanced. So the problem we have is that here we seem to have a very, very differential approach by the Court of Justice saying, we're not going to look at how much you're paying for the ambulance services. We will just trust that you are basically complying with domestic law. And then we have another case, and it's a very difficult case because there were competing appeals, and there was one against the decision of the contracting authority. There was a separate one against the decision brought by the competitor. And in the end, it was about keeping excessive capacity for the disposal of animal carcasses in Germany, actually in this state, in Rheinland-Pfalz, in case of epizootic. Here, to cut the story short, the Court of Justice came up with a third substantive standard because they were willing to look at the budgetary efficiency, but then at the same time, they actually engaged in the cost of the notional competitors. So the problem we have here is we don't know what's the standard, but with all likelihood, this is going to be a political decision by the Court of Justice. And I'm not sure that the Court of Justice is going to be willing to uphold CPBs that go commercial. So this is taking a bit long, but just this is very unknown future. And if I know anything about uncertainty, is that, we were discussing about this over lunch, you don't want to be the pioneer contracting authority if you get it wrong. Of course, you want to be the pioneer contracting authority if you're going to get it right and you're going to be in the press and the minister is going to send you an acknowledgement letter. But you don't want to be the first one to cost your member state a significant amount of money in fines or in liability. So I don't really see a lot of appetite for these things other than by the CPBs because they have the incentives. So this is going to hinge on the understanding of competition law by the advisors of the CPBs. Okay, now that I used up 90% of my time, I should probably go to the second topic. Apologies for the imbalance. The second issue are public contract registries. And this is linked to some extent because you could think that a baby step towards creating these registers is to get the CPBs, which have to be fully electronic in 3.5 days, to disclose the information that, of course, if it's electronic, it's going to be automatically gathered about their projects. So you could say, well, if a member state wants to trial it, let's create a registry of what the CPB is doing, and then scale it up. The Commission, it's not that it has suggested that this may happen, it's that it has committed to it. Because in the strategy for the upgrading of the internal market of October last year, together with the instrument for the previous assessment or the early assessment of infrastructure projects of more than 700 million, the second specific issue is the promotion of contract registers in the member states. And it needs to happen by 2017, 2018. So let's say at the latest, New Year's Eve of 2018. And it's linked to the issue of Article 84 of the proposal. So if you have been following the process, you know that in 2011, the Commission was really ambitious in trying to basically get the member states to create an independent public oversight body with very good information collection tools, and all this information will be shared with the Commission and probably publicized. The member states killed it on the first meeting of the working group of the Council that discussed the proposal of the Commission, and it never again came back. So I may be too cynical, but I really doubt that the Commission, with a soft law approach, is going to persuade the member states to do anything meaningful in this area, because the resistance is really, really big. In terms of cost, but also in terms of control. If you give the information to the Commission, procedures for infringement could just pop up like, you know, hot buns, because it's going to be demonstrated by the facts. The issue about how many tenders do you publish? Well, now we will know how many you had. So if you're publishing 1% of your total tenders, there's going to be an investigation. So this is a very powerful tool the Commission wants. This is a very powerful tool the member states, or some of them, don't want to give the Commission to play with. So I'm quite skeptical. The second thing is that the justification is quite interesting because it sounds a bit like trying to sweeten a bitter pill. The justification is that this transparency is aimed at improving the quality of the national procurement systems, allowing for control of the life cycle, and detecting anomalies. If you read both parts of the statement, they just don't match up. Because the first part, which is about improving transparency and quality, is pure administrative decision of a member state. So if you're a member state and you want to have a crap system of enforcement of procurement under EU law, it's your prerogative. I mean, you're going to be very wrong, but it's your prerogative provided you just ensure that the EU law is effective. But if it's very inefficient, if it costs you forever, that's your problem. But the second part, which is about looking at contracts from beginning to end, sounds like we have these new rules on modification and termination, Article 72, 73, never explored. We want data to be able to start reacting to that soon. And the second bit, which is about anomaly detection, of course, you know, people want to do their laundry at home. They don't want to go to Brussels to the laundry. So this is a tool of oversight. And I'm all for it. I love it. I also advocated for this. But you cannot really trick the member states into creating the oversight mechanism if they don't want it. The second issue is that the member states that have adopted this, and Vera is going to correct me because she is based in Portugal and is a specialist, so what I'm going to say about Portugal is just based on my limited knowledge. But if you do go public, you have the Portuguese experience with everything is online. So from the call for tenders to the final contract documentation to modification documents, everything is online for everybody to use. In some member states, it's about the Republic, but I don't remember now, you cannot pay any invoice unless the contract has been put online. So the member states that buy the idea go full tilt and say full transparency or no payments. Now the problem that I have is twofold. One, having the register online, and this meaning that everybody can access the register and use the register meaningfully are not one and the same thing. So for instance, in Portugal, what I hear is that yes, you have every contract, but then you have some contracting authorities that publish 20-page long contracts, and you have some contracting authorities that publish a 2-page contract, which makes reference to some schedules, and the schedules have been declared confidential. So you don't have homogeneous information. The second thing is that the information is imputed in the registry manually. So every now and then you get an error, and what should be 2 million is 200,000. So, you know, it's very hard to actually use this information in a meaningful way, even when it exists. But the ones that actually manage to use it quite effectively are the tenderers. So as a competition scholar, the one thing you don't want is transparency in the market. You don't want every tender to know what everybody else is doing, because this is just facilitating their cartelization. If they want to agree on a price for any good or service they are selling to the public sector, absent transparency, they have to meet in some sordid hotel and risk that the police is going to raid them and they're going to be convicted for a cartel. But if you put all the information out there, you're doing the job for them. And the only thing they need to do is hire a trainee, for 100 euros a month for 10 hours of work, put all that information into an Excel spreadsheet, and they monitor if everybody's sticking to the price or not. And I have an example that I'm not going to claim is what happened, but it looks really like that based on Portugal. So in Portugal, all contracts, full conditions of the contract in the public registry. And when I was hearing about this, it was actually at a meeting of the European Commission, and with my Finnish colleague, Timo Rantanen, we made just a very quick case. And we remembered that providers of prefabricated construction materials for schools had been just fined by the Portuguese contracting authority. So we said, could we look at the contracts that were the object of the sanction? And we could actually access them. And funnily enough, all the contracts were for exactly the same price. So working this backwards, what means is that the companies agreed on a price, they all tendered for the price, it was all published, so they could run it for 4 years. It was also part of the package of stimulus that Portugal implemented, so there was public money to fight the crisis by building prefabricated schools, which we think a good idea. And then after the fact, what we realized is the competition authority, looking at the same numbers, imposes a fine on them. So to me, this is the proof I was missing, that if you put all the information online, at least some industries, and the construction industry seems to be very good at this, are going to use it to cartelize. So, I'm not going to call, causality. I'm not saying one thing leads to the other, but it does. So we need to stop doing that. And the solution, in my view, is that we need to target disclosure. So public registers, yes. Fully available online? No. So who needs the information and for what? And let's start creating different layers of information that is made accessible. Let's start creating a time lag in the information that we disclose. So in the end, if we want Amnesty International or Transparency International or whoever else we want to look at the large or the long view term trends of procurement in a country, they can use 5 years old information. They don't need to use current information. So we can create a window where only people that really need to look at this have access. So Court of Auditors, full-time access. Ministry of Public Administration, Ministry of Infrastructure, full-time access. But everybody in the ministry, no. Just people that have a job linked to this, that we can right now make sure that with encryption and things, only certain people get access to the information, and that we can control. Why? Because if we don't do this, we will keep on having cartels. So this is all I wanted to say. I know it's controversial. I hope I sparked some ideas. There are some additional references for you to read in your own time, but I would love it if you can be in touch, and I'm happy to take any questions now. I think we have some time, so thank you for your attention.